Okay. All right. So anyway, without further ado, I'm going to announce our speaker for today, and that's Eric Sigmund. Many of you have already either met him, maybe used him as an attorney, or seen him speak because he's been a speaker at NEBBA Zoom meetings and in-person meetings in the past. He's a shareholder in Roberto Israel and Weiner's corporate and business law and hospitality practice groups. Okay, Eric focuses his corporate practice in the areas of corporate formation, capitalization, succession planning, commercial leasing, mergers and acquisitions. His transactional practice includes counseling clients in connection with mergers and acquisitions, asset stock purchases, buy-sell agreements, corporate formation, partnership agreements, contract drafting, and review, and other general corporate matters. Obviously, he's a lawyer. I should have said that to begin with. I assume you know that. Eric's practice has a unique focus on franchise law, including franchise agreement negotiations, franchise disclosure document drafting, analysis and review, regulatory compliance, commercial real estate, retail leasing, corporate formation, business transactions, and any related business counseling. So while he's speaking, by the way, he's going to take questions at the end. So the easiest thing to do, first of all, is to, in the chat, to put your questions there. So Eric may see those while he's speaking, or he might not. If he doesn't, he'll get to them at the end of his talk. But we do want to get your questions in, and just figure out how to do the chat. I believe you'll find you bring your cursor to the bottom of the screen, you get a little chat icon there, and you can add your questions right there to the entire group. Right, and so with no further ado, Eric Sigmund, and thank you for speaking today. We appreciate it. I'm going to
You're welcome. Thanks, Peter.
Okay.
Let me see if I can get this up here. Can everyone see that?
Yes, we can.
Excellent. Yes. All right. So today I'm going to be talking about common pitfalls in selling a franchise, and it's going to basically be an overview of franchise law, what a franchise is, as well as some of the issues that come up in a transaction. You know, it's a typical business transaction, but there's a lot of unique issues that come up that have to do with the way that a franchise is constructed and the different agreements that are associated with that. You have a third party involved with a franchisor, so it just makes things a little bit more complicated, but I've got some good tips in here about how to avoid problems. So basically, there's a few common pitfalls that I see with selling a franchise. First of all, it's understanding what a franchise is and what it isn't, and what that means. The second is that the franchisor has certain rights in the business, and just understanding what those rights are before you go ahead and start selling, or before you accept an offer. Because accepting an offer or listing a business or franchise for sale has certain implications as per the franchise agreement. And then there's some other issues that come about with franchises that sort of, can drive the sales process with it. So without further ado, the principles of franchising. So what I want to do is kind of go over what a franchise is and what it isn't. So a franchise is a federally regulated business offering. So the Federal Trade Commission regulates it, and obviously I'm a lawyer, so I got to talk about the laws here. But basically what it is it's a continuing commercial relationship or arrangement between a franchisor or a licensor and a franchisee, okay, or a licensee. The franchisee basically gets a right to operate a business using the franchisor's system, their brand, their trademark, or other intellectual property, where the franchisor exerts a significant degree of control over the franchisee's operation. So while the franchisor is giving the person the brand, right, the franchisee the brand, they're also controlling how they operate their business, a lot of times where they get their supplies from, how they do their hiring and firing, a lot of other things that come into play that give the franchisor a substantial degree of control. And it's also in exchange for a fee. Now that fee is usually in the form of an initial franchise fee, somewhere typically between $20,000 and $50,000. That fee is almost always non-refundable. It's sort of your entry fee to get in the door. And then there's ongoing fees, which include royalties, advertising fees, technology fees. So there's a fee in exchange for this license. So the three sort of prongs of the test to determine what a franchise is that there needs to be a substantial association with a trademark, and that's a federally registered trademark, and the franchisee receives a license to use either a logo or a name or some other federally registered trademark. And as I said, the fee, the courts have interpreted the fee, and the FTC has interpreted the fee as at least $500 within the first 6 months of operations. And then there's a significant degree of control and assistance along with that. On top of the federal regulation, there's also a layer of state regulation, and it varies from state to state. There's certain states that have regulations. Massachusetts is not one of them, but you can see here there's a bunch of them, and they have their own interpretation of what a franchise is and what it isn't. And as you can see from the middle column there, those states, including Rhode Island, which I guess is relevant to our group, slightly tweaks the federal definition of what a franchise is. So when you're in one of these states, the franchisor usually has to register their offering with a state agency. Connecticut, Missouri, New York, and New Jersey have a two-pronged test where basically there's a written agreement, and there's what's called a continuity of interest, which is a continuing financial interest between a franchisee and a franchisor. So as you can see, it gets pretty convoluted. You have a federal definition where, if you qualify for that, you've got to meet the FTC guidelines. And then if you're a franchisor going into any of these states, you also have to comply with the local laws. So why is franchising so appealing to a franchisor? Basically, it's a way of a company expanding its brand while taking on less risk and lower costs. So you can essentially take your brand and expand your business by putting the risk on individual independently owned businesses. So if I'm a franchisor and I want to franchise my donut operation to Peter, I give him a licensing agreement with my brand and everything else, but Peter's got to go out. He's responsible for the build out. He's responsible for the lease. He's responsible for paying for supplies. He's responsible for basically operating his own business. My obligation as a franchisor is just to supply a brand and enforce and maintain brand standards. So it's very appealing. It's a very appealing way to grow your business. However, there's a downside to it. It is, as I said, very heavily regulated. There's an FDD, which is a franchise disclosure document, which is a federally mandated document. If you're going to franchise, you need to provide a certain level of disclosure to potential franchisees. So if it meets the definition that I just talked about, you've got to provide this document. And these are pre-sale disclosure requirements. And that actually factors into transactions, as I'll get into a little bit later on, because there's a 14-day cooling off period. So if you have a client who's selling a franchise, that needs to be taken into consideration in the sales process, because the buyer will need to be disclosed, wait the minimum of 14 days in order to sign a franchise agreement. It also requires audited financials, which can be very expensive. And there's a lot of consequences for not complying with the franchise rule, which include a bar from conducting business. A lot of the states will prevent a franchisor from continuing to offer franchises or even operating within the state if they violate any of these rules. Another big problem for a franchisor is that if they fail to comply with these guidelines, the franchisee will often have a right to rescind the franchise agreement and basically get their money back, which is not in the franchisor's best interest. There's also a lot of law out there and a lot of case law about joint employer liability and vicarious liability for the franchisor, where they end up being responsible for the acts of the franchisee. It's a very sort of cutting edge, murky area of the law. There's a lot more to it than what I'm saying, but it's a risk for the franchisor. So there are some downsides to it. So I call a franchise basically a business in a box, and it's a ready-made business model. So as a franchisee, you get this franchise agreement. The franchisor gives you an operations manual. They give you all the things that you need to do to operate the business from day one, as opposed to you trying to come up with that stuff yourself as a franchisee. Some of the downsides is that there's often restrictions on sources of products, operations, pricing, all that type of all those types of components where you have independence, but not complete independence from the franchisor. There's also often territorial restrictions where you can only operate a business within a certain area. Another risk I say here is, what if the system's broken? What if the franchise really isn't great? What if the franchisor the brand isn't great? What if, they don't have great support? Those are risks for a franchisee. And there's also little room for negotiation in there. So as you can see, it's kind of a complicated area. And I get a lot of calls from people who have a location of a business or, a couple of locations, and they've heard about this great concept called franchising, where they can make all this money, but they don't realize the risks and the regulatory components of it. I mean, just to get the FDD going and get the branding and everything, it's a tremendous investment. And then on top of that, you'll then have to go out and sell franchises. So you go from being in the business of, operating a pizza shop or a restaurant or, some other sort of business, to being in the business of franchising, which is completely different. And again, it's a very heavily regulated area, so there's a lot of risk there. So what's not a franchise? So Starbucks isn't a franchise. It's a multi-location business. It's all owned by the same company, right? There's a lot of businesses out there that are multi-location, and sometimes people call those franchises, but they're not truly franchises unless they meet the definition that I mentioned earlier. A distributorship agreement is also not a franchise. And it's important when you're selling a business to understand whether it's a distributorship or whether it's a franchise. In either case, you're going to have a contract between, either the franchisee and the franchisor, or the distributor and the, manufacturer that will govern the operation of the business, but it will also govern, assignment of that agreement and transfer of that agreement. And it's also not a dealership. Okay? That's a completely different arrangement. And it's not regulated. So you have to meet all three of those prongs that I mentioned earlier. So understanding what the business is that you're actually selling and whether it is in fact a franchise is an important step and an important thing to understand in order to avoid some of these issues that I'm going to get into in a little bit. So the franchise relationship begins with an FDD. As I mentioned, this is a franchise disclosure document. It's mandated by the FTC. And essentially what it does is it provides information. It's almost like a prospectus. It's got 23 items. And the idea is that you can take an FDD from McDonald's and an FDD from Dunkin' Donuts, lay them next to each other, and get the same information about the offerings and be able to understand them in plain English. These are often very complicated, very sophisticated relationships and arrangements. So understanding not only the contractual obligations, but also the financial and other obligations that go along with the offering and along with the franchise is very important. So this is why the FTC requires that franchises have these, so that people are going into these things theoretically with eyes wide open. So there's 23 items, as I mentioned. Here's a few of them. I've highlighted throughout here some of the more important ones when it comes to selling a franchise. So when you're listing a franchise for sale, it's important that the buyer understands that there's fees involved and that they understand that they're getting into a business and they can see a gross profit or a gross income, but that's also, you've got to factor in the fees. The buyer's got to understand those fees, as that's going to affect their bottom line. There's also obligations. Item 9 lays out all the obligations and essentially summarizes the franchise agreement. And, if you're ever looking through an FDD and you don't want to read the 50-page contract, you can go to that section and you can kind of figure out where certain things are located in the franchise agreement and also get a good summary. It usually summarizes the provisions that have to do with, default, and then, what's more relevant here, which is transfers of franchise agreements. Territory is also very important because there's different types of territorial models in franchise. There's an exclusive territory, and then there's a quasi-exclusive territory. And there's a lot of different types of variations on it. You have territories where the franchisee is only able to sell and operate within a particular area, and that's defined as a town, a county, zip codes. Sometimes they just draw it out on a map. There's other ones. Service-based franchises will typically have a model where you're only allowed to, it's called the designated marketing area, and you're only allowed to market within a particular area, but you can take clients and you can take business from outside that area. areas. So if you have like an IT franchise, for example, and you're only able to operate within Boston, you're only able to market within Boston, but somebody refers you into some, client that's out in, Worcester, you can take that client, you just can't market to that client independently. So it's a subtle distinction, but that's important for a buyer to understand, and it's important for you as brokers to be able to disclose that information properly so that the buyer can understand where they can actually operate and market their business. Item 17 is also an important item. As I mentioned before, it talks about renewal, termination, transfer. Franchise agreements are typically 10 years long, although I've seen some that are 20, some that are 5. They almost always have some sort of a provision in there about renewing the franchise. So again, that's an important thing to understand as you're selling a franchise. Are you in year 9 of 10? Or is the buyer going to have to exercise an option immediately? Is the buyer even assuming the existing contract that the seller has? Or is the franchisor going to say, well, wait a second, we're going to start over and you're going to get our new contract? And if so, how different is that new contract? Is that new franchise agreement from the one that the seller signed? Are the franchise fees different? Was the royalty fee for the seller 5%, but the royalty fee in the new franchise agreement is that 8%? And how does that affect the bottom line for the buyer? Another important item is item 19. It's probably one of the more heavily scrutinized sections or items. The FTC basically says if you're going to disclose any financial information about the franchise offering, any sales figures, any data about the financial performance of the business, it has to be located within item 19. It has to be in writing. You cannot deviate from that. And there's even more regulations on that. The idea is that they don't want franchisors telling franchisees, hey, you're going to make millions and millions of dollars when the business is actually not performing at that level. And this is an important area of due diligence for a buyer to look at the FDD and to understand, not only what this business that they're buying is doing as far as, financial performance, but also what other franchises are doing across the country, across the system, and understanding how their business that they're buying is different from the ones that are disclosed. So that's a very important disclosure. The other item is item 20, and that's information about existing franchisees. I always encourage buyers and new franchisees to contact as many existing franchisees as they possibly can and ask them about the franchisee's experience in the system, how the franchisor is with training, how they are with support, what they've done as far as marketing and branding within a particular area. These are important questions, and it's important that a buyer gets to understand what they're getting themselves into. So that's a very high level review of the FDD, which is a very complicated document. I don't know if you've ever seen them, they're 300, 400 pages thick, and they contain a lot of information. So they're very rich documents that need to be very carefully scrutinized on both sides of the deal when you're involved in a franchise transaction. So when you're selling a franchise, there's a franchise agreement, and that agreement connects itself to a particular territory, a particular franchise. So when somebody's looking to sell that territory, when they're looking to sell that business, the franchisor has certain rights in the business transaction. There's always a clause in a franchise agreement. It's a section. I don't know if any of you have ever reviewed a commercial lease. It's similar to the assignment provisions in a commercial lease, where there's a prohibition on assignment, or there's something that says the franchisee cannot assign the franchise agreement without the franchisor's consent. And the definition of transfer or assignment is usually fairly broad. So it would include, a sale of the assets, a sale of the stock, sometimes even just changing business entities for the franchisee. So the franchisor has a lot of oversight, a lot of rights when it comes to a business transaction. So one of the other pitfalls that I see is not understanding what those rights are until it's too late. The franchise agreement has a lot of different provisions in it. There's a generic agreement that's included with the FDD. So if you can't get your hands on the actual agreement, there are ways of getting a sample of it, and it can basically show you what the basic provisions of the franchise agreement are. This is the document that forms the legal relationship between the franchisee and the franchisor. I have people that come to me and say they want to sign an FDD, and I say, you don't sign an FDD, you sign a franchise agreement. The FDD is not a contract, it's a disclosure. The franchise agreement is the actual agreement. So the basic elements of a franchise agreement are, there's a section on ownership and use of the marks in the franchise system. So as I mentioned, a franchise is a license of intellectual property rights. So the franchisor owns the intellectual property. And in fact, they own the goodwill of the business. If you read the contract very strictly, all of the goodwill inures to the benefit of the mark holder under trademark law, and the franchisor owns the trademark. So the franchisee doesn't actually own the goodwill of the business, technically, although usually in an agreement, a purchase agreement for a franchise, there is, the goodwill is included in the assets to the extent that the franchisee can sell it. So that's another thing to kind of keep in mind. As I mentioned, the franchise fees are a very important part of selling a franchise and understanding what those are. There's also restrictions on sale and transfer, as I mentioned, but a lot of franchise agreements will also contain a right of first refusal for the franchisor, where if the franchisee gets an offer to purchase their business, the franchisor actually has a right of first refusal. I have almost never seen a franchisor exercise the right of first refusal. In some cases, they will, if it's either a very well-performing location and the franchisor is contracting and they're looking to kind of buy some franchises back. But it's very rare that a franchisor will exercise a right of first refusal on a franchise territory. They're in the business of franchising, they're not in the business of running franchises. So they want to keep that separate. Another portion of the franchise agreement that you have to be aware of when you're selling a franchise is the confidentiality provisions. The operations manual is a trade secret of the franchisor, and they protect that diligently and vigorously. So if you have a seller client who wants to give the operations manual over to the franchisee, you have to make sure that they're under an NDA. And even then, it could potentially be a breach of the franchise agreement for that buyer, for that seller to give the buyer a copy of the operations manual. You have to be very careful with that. There's also always a covenant not to compete in a franchise agreement, where the franchisee is not allowed to compete after termination or transfer. So I know that in a lot of transactions, buyers will ask for a non-compete from the seller. So it's important that you understand what that covenant not to compete looks like in the franchise agreement, so that if you're representing a seller, you don't have a situation where the franchisor has a 2-year non-compete and the buyer's asking for 5. So, you got to just understand what all those provisions mean and how they kind of work together. So many franchise agreements, as I said, contain a right of first refusal for the franchisor. And some franchisors have very specific processes on how that works. It's all outlined in the franchise agreement. And I always recommend that the seller gets a waiver, something in writing from the franchisor saying that they waive that right of first refusal. So I have a transaction going on right now, and the franchisee, my client, the buyer, had to wait the 14 days for disclosure under the FTC regulations. So they got the FDD, they had to wait 7 days. And then there was another 30-day waiting period for the franchisor. Now, the franchisor doesn't have to wait 30 days to waive their right of first refusal. However, that's what the contract said. So they could go on day 29 and say, either they don't want it or they don't want it. So understanding that in your sales process is very important, because if you don't get that right, you could be in a situation where you've got to wait a month or two before you can do anything, because you have to wait for the FTC mandated 14-day waiting period to expire, and then you have to get a waiver from the franchisor of the right of first refusal. Again, very rarely have I ever seen a franchisor actually exercise the right of first refusal. Again, most franchise agreements don't allow transfers without the consent of the franchisor. So getting that consent and getting a waiver of the right of first refusal is very important. And the timing of that depends on the deal and the comfort level of the buyer. Some franchise agreements will contain compulsory broker fees or some sort of a commission that if you sell your franchise, essentially either the franchisor gets to pick their own broker, use their own broker, or they'll charge a commission on top of it if they bring the buyer to the seller. So you really have to understand that process. That's usually outlined in the transfer provisions. If it's an existing franchisee in their system, or if it's somebody even that they may have had contact with in the past, if you're brokering that deal, you've got to make sure you understand how that commission structure and that brokering, arrangement works with the franchisor. And then on top of that, there's training and transition that the franchisor will give any franchisee, but how that works with the seller's training and transition that's typically in a deal is an important thing to understand as well. This is an example of a transfer provision. It basically says that, the franchisor has vetted this franchisee, they're relying on the information that they've given. They like this person, they're giving it to them. So as a result, they're basically saying we can withhold our consent to a franchisee in our sole discretion, or in a lot of cases, reasonable discretion, depending on whether your potential buyer meets the franchisor's minimum criteria. So if you can get your hands on that before you sell, or as you're going through the sales process, and understanding what exactly that looks like is probably a very important thing to do as well, although that can be kind of difficult. But it's just another, hurdle, or another thing that you need to worry about when you're selling a franchise, is just getting through that consent process and understanding what that's going to look like. Sometimes the franchise agreements will actually have the criteria in them. So looking at the franchise agreement is very important as well. So there's also conditions on a transfer. So, sometimes the franchisor will require that any defaults that are under the franchise agreement are cured. So if you're representing a distressed business, understanding whether they're current on their franchise fees is very important. They'll always require payment of a transfer fee. Who's paying the transfer fee? Is it the seller? Is it the buyer? Are they splitting it? How's that going to work? Is the buyer assuming the existing franchise agreement, or are they signing a new one? As I mentioned, that may have an impact on the timing of the deal. Another important thing to understand is with a brick and mortar franchise, sometimes the franchisors will require that the seller update their location to the then current franchise standards before a transaction, or they'll require the buyer to do that. So understanding what that looks like is important. Some franchises will go through and audit the location and see if there's any issues, and they'll make the seller fix them all before they'll consent to the transfer. And then another question on timing is, does the franchisor require that the training for the franchise be completed prior to a transfer? Again, if you think about it, you've got a 14-day waiting period. You've got to, waive the right of first refusal. And then is the franchisor going to say to the buyer, you've got to complete 3 weeks of training before you're closing? So, again, as far as timing, understanding what that process looks like. There's some additional unique issues. There's landlord issues, as with any transaction. Sometimes there's an interplay between the franchisor and the landlord. Whether the franchise is SBA approved, is the franchise you're selling on the SBA's approved list, where the SBA will lend to these franchises? That's an important question to understand, because if you have a buyer that comes to you with an SBA that wants to do an SBA deal and the franchise is approved by the SBA, then that could further delay things. And then, of course, as I said, there's the 14-day cooling off period. So understanding the timing issues with that. So that's a very quick summary of some of the issues with dealing with a franchise sale and some of the pitfalls that I see. So I guess we got a few minutes left, so I'll open it up to questions.
Okay, so who has a question for Eric Sigmund? No charge for these questions. He's not billing you. Don't worry about it.
Eric,
Yeah.
Eric, I have a question. Bob Carl is here.
Hey, Bob.
In the past, when I've done some franchise sales, I've come across the list of acceptable and good franchises and poor franchises. Is there a way to get access to such a list? I don't know where it's published, but I sure know there's good ones and bad ones.
Yeah, I think, going to the International Franchise Association has some data on that. There's some rating systems out there. You can kind of poke around. I would start with it's called, if you do IFA, if you Google IFA, it'll be on there. They also have a lot of really good information in there about, you know, buying and selling a franchise, what a franchise is and all that, but there should be some data in there, and there's publications out there that you can look at as well. If you have any questions on that, I can get you some stuff, but there's definitely a lot of information out there.
Thank you.
Yeah, no problem.
Eric, there's a number of questions. We can still take them verbally, but there's a number of questions in the chat as well.
Okay. The first one I see is, what rights does a franchisor have if it has not filed an FDD for several years and registration states in that? So basically, if you don't have a current FDD, you can't sell franchises. So if you're selling franchises going along, you have an FDD, and then you stop selling them and you don't have a current FDD, which needs to be updated every year. If it's in a registration state, it needs to be registered every year. So if you fail to do that, you're not allowed to sell franchises until you've provided a current FDD and a current disclosure. Does that answer the question?
Hi, Eric, this is Jeff. I asked the question, what about the franchisee's ability to sell if the franchisor hasn't filed the FDD?
So any buyer of a franchise has to be disclosed. So if a buyer is looking to sell and the franchisor does not have a current FDD, that's a big problem for the seller because they have to wait for the buyer to be properly disclosed. So most good franchises will have an FDD that they renew every single year, especially if they're in a registration state. So, you know, again, sort of as I mentioned earlier, understanding who the franchisor is and doing the due diligence on that as you're getting a listing is very important.
Yeah, but if it's not a good franchisor, what options that the franchisee have other than to terminate, or you talked earlier about rescinding the franchise?
Yeah, I think that, you know, that would be one of your options, is to basically go to the franchisor and say, I need to transfer this thing. There's you know, a procedure in the franchise agreement for transferring it. I can't do it because you're failing to, you know, provide a current FDD. And, you know, these FDDs, like I said, they're 23 items, they're 300 pages long. You can't just throw that together in a week. So, you know, I think going to the franchisor and trying to negotiate with them, and if you can't, trying to find a way to rescind the agreement or terminate it and get out.
But if you get out, you can't continue the business, right?
Correct. In a lot of cases, you'd have to reach a settlement, and you can, you know, there's been some franchise concepts where people have gotten out of the franchise agreements. They can't use the intellectual property and they have a non-compete, but the franchisor will let them out and do what we call flipping the sign. So instead of being Eric's Fitness Center, it would, or being, you know, Planet Fitness, it would be Eric's Fitness Center, and they will allow the franchisee out of its obligations. So that does happen sometimes.
Thanks.
All right, what else we got here? If you're buying a failing franchise unit, how do you keep the seller while you're in purchase and sale agreement from not reducing the revenue or operations further?
Franchise, how do you keep this going?
I'm not sure about that.
So if you know, again, if you're buying I mean, it's from the perspective of a buyer, it's all about due diligence, right? And it's all about making sure you have a contract. And if you have a purchase agreement that, you know, has reps and warranties in it, and covenants, that, you know, you make sure that you have a covenant in there that the business is operated in its ordinary course. You know, that's basically all you can do. And that would be a breach of the purchase agreement. So if the revenue, if basically the seller takes their foot off the gas and the business declines over the course of the time when you sign the purchase agreement and the closing, you may have a way to get out.
Okay, and if a franchise is not SBA approved, is there a process to try and get it SBA approved?
Yeah, I mean, I defer to the SBA lenders on here, but I know that there's a list, and I know that there is a process to getting it approved. I've helped some clients that have had franchises get them approved. There's even consultants out there that will do it, but there's a whole process that the SBA has, and they essentially vet the FDD and the franchise opportunity. So there is a process.
Okay, and Steve Mariani, is that, I think we just already got Jeffrey Starfield's a question verbally, but Steve Mariani asks, can anyone check to see if the franchise is SBA financeable?
Again, deferring to the lenders, but I think if you go to any SBA lender, they can look that up pretty easily.
I think so too. Who do you see typically pay the franchise transfer fees?
Under the franchise agreement, it's the obligation of the seller. So, you know, from a buyer's perspective, I would say that's between the seller and the franchisor, but you know, it depends on the deal. Sometimes buyers will offer to pay it as a way to sweeten the deal. Sometimes the parties decide to split it. But a lot of times buyers will, like I said, sort of say, hey, you know, that's your problem. That's part of your cost of doing business. But, you know, I've seen it all three ways. Buyer sells it, or buyer pays it, seller pays it, or they split it somewhere.
Okay, I have a question for you of my own. I recently, well, a few years back, I was dealing with, it's a specialized advertising company, and their model had been that they had licensed locations throughout the country. So licensed to use the branded name and you know, certain requirements for where they were to obtain the materials and other business practices. But then they wanted to convert it to a franchise. And then at some point, I believe the licensees, they wanted them to convert to franchise, but they could also stay as a licensee. So is that an unusual situation where you've got, and what is the difference between being a licensee versus a franchise of a franchisor?
That's a really good question. If you, and that is not uncommon, but you got to look at the definition of the franchise. And I would assume they'd have two sort of separate agreements. They'd have, you know, a franchise is, you know, a license of a brand with a significant degree of control. And there's a lot of litigation out there and a lot of commentary on what that degree of control is and how you define that. And then there's got to be some sort of a fee. So as long as you don't meet those three criteria, you're not a franchise and you're not subject to the FTC guidelines. So it would take somebody, you know, an attorney who's very well versed in the franchise rule to draft those documents properly, so you're not accidentally, you know, having those licensees be franchisees. Although I would say it's a little blurred, because if you have the same brand and some people are franchisees and some aren't, it's kind of hard to, you know, maintain that one's not. Do you know what I mean?
Right. So what you're saying is, in other words, those licensees could be inadvertently treated as a franchise if they were sort of controlled thoroughly enough by the franchisor or the licensor.
Yeah, and actually
Sort of fit into that mold.
There's a question here that just popped up from Jan about an accidental franchise, and that's exactly what we're talking about. It's when,
okay.
Yeah, it's when you have a business that you're or you have a concept that you're licensing, and you're acting like a franchise. You meet all the criteria, but you haven't gone through the necessary regulatory steps, right? And that's when you're an accidental franchise. And I've actually gotten people out of licensing and distributorship agreements under that theory, where I've said to the licensor or the distributor, hey, this is a franchise. You can let us out, or, you know, we got the FTC that we can go to, right? And, you know,
okay.
And
so
if
it creates a peril for the licensor, because they've essentially structured you like a franchise, and because they don't have the FDD and all those things that a franchise would have to do, you can say to them, listen, you have to let me out of my license agreement, because essentially you're operating an illegal franchise operation. Is that what you're saying?
correct.
Okay. Interesting.
Yeah, it's very interesting. A lot of case law on that as well.
And I believe Jonathan Smith looks like he put up a link. Thank you, Jonathan, which looks like, is this, Jonathan, I assume that this is a list of the approved franchises?
No, Aaron put up the list of the approved franchises, but someone had asked earlier about, you know, finding, you know, whether a franchise is a good franchise or what the metrics look like. But FranData is a resource that we as a bank use, where you can get their, you know, basically any franchise's scorecard as to, you know, what the financials look like, you know, transfers, closures, any data that you want, you can essentially find from the Fran data site if you wanted to drill deep into it.
Okay.
And actually, a lot of that information is also disclosed in the FDD about transfers, renewals, terminations, number of outlets, all that.
All right, so in the resources here, but if you want these links, save them as bookmarks, but you've got a list of the SBA approved franchises and source data for the franchises right there in your chat session. Okay, good. Any other questions out there? You can just go verbal, just unmute yourself and feel free to speak up.
Hi, Eric. This is Steve Roche. Thanks for the presentation. You had mentioned relative to the timing as a broker on taking on one of these franchises and getting, the consent to sell from the franchisor, as well as the waiver of the right of first refusal. I know you had mentioned maybe the timing is different on that, but from when you take them on, is it even before you have a buyer for that franchise, should you get that waiver right up front before you even list?
So I think it's important to understand what that process looks like when you do get a listing. But a lot of times the right of first refusal is structured in such a way that they can't even exercise it until the franchisee gets an offer. So you can go to the franchisor and you can say, hey, I just listed my business, and get something in, verbally that says, hey, I just listed my business. Would you exercise your right of first refusal if I did, and get something from the franchisor that just, get an indication, get a read from them on that. But a lot of times they're structured so you can't actually get a formal waiver until you actually get, a formal offer. So there's a little bit of a process there, but I think my point is just try to just be aware of it and try to stay ahead of it if you can and understand that it's there.
Thank you.
Yeah.
Eric, I have one quick question. So the franchisor likes to tell you when they present the franchise agreements, like, this is our agreement, like, you can't make any changes, like, this is how it is, so forth. But like, we know that there is always some wiggle room. Like, what are the key points that like you typically see changes to be made?
So it's a great question, and I get it all the time. I think if you go to Dunkin' Donuts or McDonald's and you ask them to make changes, they're going to say no. I think if you go to any franchisor and you ask them to change, their royalty fees, they're probably going to say no. There's certain things that they can't change without having to redisclose. They basically would have to stop selling franchises, revise their revise their FDD, and then, basically redisclose at that point. So there's the implications to doing that. I think, things that I've had success with have been less on the business terms, as in, like the franchise fees and that type of stuff. Territory is a good place to go. You just sort of, the franchisor will have a territory that they've kind of thought about, but there's room to negotiate there. Sometimes you can negotiate like a waiver of fees for like the first 3 months or 6 months or something like that. Limitations on a personal guarantee is also something, because all these franchise agreements are personally guaranteed by the franchisee. So some sort of a limitation on that is another area. But it really is going to depend on the leverage that the franchisee has with the franchisor. If you're one of the first like 10 franchisees in the system, you're going to have a lot more leverage than if you're the 500th franchisee, because the first 10, the franchisor is just barely getting off the ground, and they really need the franchisees to sign so that they can start, getting the momentum to start selling more and more of them. So you can usually get a lot more at that point. But I found more luck with negotiating the legal terms, I'll call them. So things like personal guarantees, indemnification, things like that, as opposed to the business terms.
Got it.
So by the way, the best question I've got here, or comment I should say, is what Joshua Meltzer just put up, which is, make sure your agreement with the franchise owner pays you even if the franchisor exercises their right of first refusal. That's the best one. We got to make sure we get paid. So what would be the language there? I guess I'd have to give that some thought, but
I think that would, in your listing agreement, would have to go into your definition of what a sale is, right? And you'd have to list as one of the things, you know, if the franchisor exercises its right of first refusal, which would be a sale, right?
Well, if you transfer the assets, that's a sale. Hopefully, yeah, but it would be nice to make clear that even if that person, the buyer is the franchisor, maybe something like that just sort of thrown in there. Good point, Joshua. I see his picture there, but not his actual live face, but that's okay. He's got a nice smile in his picture. There he is.
Great point.
Thank you, Joshua. Okay. Okay, any other questions before we sign off?
I have a quick comment, and that is I found in my experience, it's always best to contact the franchise mother company very early on, make sure they know the units for sale, and build a relationship. You can reinforce that you're going to bring forth qualified buyers, etc. And it really builds a lot of comfort and support. They hate surprises. So build that relationship early, keep them involved in the process, and it usually goes very well, I think.
I agree.
Okay, so very good. Listen, Eric, this was a fantastic presentation. I'm sure everybody really enjoyed it. And thank you very much for NEBBA for doing this and for all the work you do for NEBBA on the board and so forth. Thank you for your contribution. Appreciate it. Okay, I guess we're going to sign off then. Listen, everybody, stay cool over the next few days. It's going to be a hot one, at least for those of you that are here in Massachusetts or in New England, okay? Enjoy the rest of your day.